This is Good Morning Uganda Extra.
Thank you so much for being with us on UBC TV. Welcome to the Extra. I'm Robert Chirabo Nyonyi Ntono. And this morning, I'm very humbled because I'm having people from the legal fraternity, and not only from the legal fraternity, but I have people from the judiciary. And we are going to be discussing something very, very important. Some of it we may not understand it. Till today, I was very sure it is a constitutional right. Before we got on set, I was told it's subjected to application, and then the judge, the presiding judge, is the one to decide. Before you guess, we are going to be looking at all you need to know about bail. All you need to know about bail. You never know when you can be before a magistrate, and all you need is bail. Remember, being arraigned in court does not make you guilty of an offense unless you've been convicted. Anyone can be a suspect. Anyone can be a suspect. About bail is what you're going to be discussing. Join me, welcome His Worship James Eremie Jr. Mawanda, who happens to be the Judiciary Public Relations Officer. Jumire. Judiciary Public Relations Officer. You're most welcome.
Yeah, thank you very much for hosting us this morning.
And just right to me is a man who is of late very, very popular. Almost every news bulletin is one you will not miss without seeing any news bulletin in this country of late. For reasons, I think where he's stewarded, I don't know. Maybe he will throw some light to that. That is His Worship Ronald Kayizi, who is the Chief Magistrate, Buganda Road Court. You're most welcome.
Thank you very much, host.
And with these two, I'm going to be discussing bail, like I told you. Now, let me begin with His Worship Ronald Kayizi, because most of the times he's the very person I see on TV whenever I turn on. Hope today I won't see again someone who was applying for bail in this Buganda Road Court, and either he denied, like the most there is an ongoing case where a passport has become an issue, or he granted bail. Now, to begin with you, Your Worship, what is bail?
Bail has a technical definition, but for the viewers to understand, bail in simple terms, bail is the release of an accused person by court pending the determination and conclusion of the case, on an undertaking that this person will come back to court to stand trial, or will come back to court wherever is needed. Simply that is it.
So it's temporary freedom?
It is temporary freedom.
But you have to report whenever needed?
Yes.
Now this takes me to His Worship James.
Yes.
Now, who is entitled to bail?
Our criminal procedure. First of all, I want to say good morning, our viewers. And I bring you salutations from the judiciary, top management, and we love you so much. That's why we keep coming here, to educate our people, to tell them the myths, okay, the issues they hear, and the rumors. Because a lot of people have been fed with a lot of lies, and some of these lies are deliberate to malign and also cause a lot of mistrust. Charged with a criminal offense in Uganda has a right to apply to that court for bail. Every person. So the standard is, are you charged in court with a criminal offense? If yes, you have a right to apply for bail. It's a constitutional right to apply for bail.
Now again, I'll need you on that. Bail, is it?
It is constitutional to apply but discretionary to be granted. The presiding judge has the discretion to agree to give you the bail or not to. But at all points, he gives reasons why.
He hasn't. So our viewers should understand the fact that you've been arrested and applied for bail is not therefore a must that you get bail.
Absolutely. Absolutely. Because the court has a duty as an independent arbiter to listen to this matter and return a decision at the conclusion of it. And between the trial and the conclusion of the matter, okay, our criminal justice will have brought the suspect called the accused person before court. And the court, upon the application of the accused person before the court, would then issue what we call a pretrial remedy. Pretrial remedy of bail is discretionary upon satisfaction of the court that you shall be returning to court at every time when you are needed. And if you are unable to return to court, sureties must be available to inform court what has happened with you, what court will always move. The aspect here is we want to allow you your freedom because you are presumed innocent until proved otherwise. Now in that process, we cannot keep you in prison if you can satisfy the conditions the court will set. So the court hears your application. All parties in the matter, for instance, your accused person, you may have a lawyer or yourself, but there is also prosecution. So you make your application to court, the prosecution is given an opportunity, and then the court takes a decision. Okay? Where there is no flight issues, flight meaning somebody may abscond, in the mind of the court, if there is nothing like that, the court will always grant. And the grant of bail is either cash or non-cash. The conditions. So the presiding officer will assess the situation, look at the facts before him, and will make a judicious decision about whether or not to grant the bail.
I get it proper. And so our viewer, most of the times where people, we've seen them come out and say, you're depriving this person of their constitutional right, the fact that we applied for bail, why are we not being given bail? This is politicizing. Judiciary is now into politics. How can you refrain this person? His worship has put that very clear. But I also want to hear from
Yes.
Your worship, guys.
Yes.
Still on that, because yeah, I think here I've even had you being nailed for.
I don't deny bail. I set conditions for bail. If you fulfill them, you go home. If you don't, you either apply for review or apply the High Court for bail. Because High Court, a magistrate or chief magistrate, if it denies you bail, you have a right to apply to the High Court to release you on bail. So you don't have to crucify this magistrate. He's not the last person. No. You go to High Court.
Now, where do I apply for bail?
Depends. It depends. There are cases that are tried by both the magistrates and the High Court. With those offences, you can apply for bail in the magistrates' courts. The offences that are tried by only the High Court, like a murder, rape, defilement, aggravated robbery, aggravated trafficking in children, for such offences, before the High Court, in the proper circuit or at the division. Yes.
Now, Your Worship James, let's look at what court considers to grant bail.
Oh, yes. There are many factors that the court considers. But I want to first get back to where my brother is. The generation there is failing to understand his role as a judicial officer. As a magistrate's court or as a chief magistrate, as long as there is an application. First of all, anyone who appears before a court, the court informs them of their right. After arraignment is when a charge is accused of that offense, when before court. In a language that they do understand, to determine whether they are admitting the offense or they are denying the offense, what we call a plea of guilty or a plea of not guilty. At that point, when the court is sure the person has not admitted to the offense, will inform the person that you have a right to apply for bail. Okay? Now, the onus of now applying for bail is on the other person having been informed. Okay? When the application is made, and this is why I want the public to understand, once you make that application, the court will listen to your application. You will give your reasons why you want to be granted bail or not. The key considerations we look at as court is, are you not a flight risk? Are you not going to escape returning to court to have the matter tried and finally disposed of? You see, court must ensure that you have substantial sureties, okay, where the court thinks sureties are necessary. The court can even release you on your own recognizance, meaning that you may not need sureties.
Oh.
Yeah. Yes. Okay. But it depends on the particular case. If it's a very serious, sensitive matter, certainly a court would want some sureties. But if it is a purely, we have done this. When I was still a trial judicial officer in courts, I will not mention the parties, I would give people bond. Okay? Why would I give people bond? Because I'm satisfied they are not a flight risk. Being satisfied that their place of abode is known. Okay? They have employment. Okay? So they would not want to run away and leave their employment. They have a family. Okay? They have a home. They, you know, those factors come into play to determine whether somebody, if released on bail, will return to court and have the matter progress. What about the interference with which, if you are a type of person and there is facts placed before a court that you are likely, or even you have so far interfered with witnesses, the court may deny you bail. If you are a type, before you coming to court, they had to run around the whole world looking for you. You, okay? And there is possibility that if granted bail, you may still run away, get out of jurisdiction. The court may consider asking, say, for your passport, because it's the passport that you will need to
run around.
And we know Ugandans now, we have come to know they even have multiple passports. And as a judiciary, we are going to do an integration with other government agencies such that we are able to tell whether somebody has only one passport or program. You see? So that we are able, if a passport is asked, we are able to tell whether it is the passport and the genuine one, or you don't have multiple passports, because you will still use the others we don't know to run out of the country. But what is the essence here of keeping you around and ensuring you return to court is for justice to prevail. Justice must not only be hard to be done, but must be seen to be done. There is a complainant. By the time a matter comes to court, a complainant has had pains, has had injuries, damages. They want justice. And here you come to court, and then you see the court does not take into consideration all of those other factors, and then releases you, and then you run out of the country. You can imagine what backlash will come to us. The complainants will really think the judicial officer was bribed to release this person, so he to defeat my case. So the judicial officer has to balance these issues and certify himself that, you know, this person upon these conditions or without these conditions is not a flight risk, and he's not going to interfere with the cases. He will return to court. He's from here. He's a man of integrity. He's a man of personality. You see? So he has a job here. He has a family. Let him get back home and we proceed with the case. So we have standard conditions that we look. They are not a given that all of them must be met, but what's critical is the judicial officer's capacity to be satisfied that this person, once released on bail, will return. And bail can be cash, can be cash. So when you hear people being directed to deposit certain chattels and all items, it is simply for purposes of the satisfaction of the court that yes, once that is done, this person will return.
Now here I want to bring in Your Worship Kaizi. When you talk about cash, and for the cash, what determines the amount? There was a case of Mirembe, I think Chirabo, and the names are still the doctor who murdered. Chirabo and I think Mirembe. And I thought the money was a lot that was asked for the sureties, but in a twinkle of an eye, it was deposited. Now, as you take us through,
now you can see.
You
may think it is too much, but people are ready with the money.
Sometimes you're like, maybe a member of parliament, they have money, and then you hear
they don't have it.
No, funny enough, when you hear non-cash of 1 million, hey, for sure, really, these people have this 1 million. So, Your Worship, take me through that.
For court to determine whether bail should be cash or not cash, and how much should be paid by the accused, and how much bond should be executed by sureties, we still get back to the nature of the offense. What is the person being charged of? A case like assault cannot be treated the same way as a case. For example, I have a case where I alleged to have stolen 7 billion. So when I'm assessing the two, I put on lenses, normal lenses, and say, no, this one may be not cash, afraid not cash. I can say, now this one 7 billion, what do we do? How do we ensure these people can come back? Because that money that you pay as cash is not our money as judiciary. We don't take it. It's not money for government. That's your money. We're just keeping that money for you. The case, whether you have been convicted or you have been acquitted, you still go back and claim that money. You just fill in a form and within 10 days you have your money back. So all that our intention is to ensure that you come back. So we normally consider the gravity of the offense, severity of the punishment, to determine that money. And they pay. Recently I had a matter where my colleague had bonded somebody 50 million. A shooter had executed a bond of 50 million on cash. He had sued for his son, and the son went out of the country to UK. And I told this lady that for to look for your son. If you trust the son, he said the son is out of the country. He said, now pay the 50 million bond, which you executed. And she indeed paid. So sometimes you may think the money is a lot, but it's not. So it depends on the nature of the offense, the gravity of the offense, for court to determine whether it should be cash or not cash. Sometimes you may even consider this.
I've heard of land titles being deposited.
We get back the same issue, gravity of the offense. You have given us an example of Chirabo's case where 100 million was paid, and to you think it was a lot of money condemned. So the major consideration is gravity, nature of the offense.
Yes. Very interesting here.
Maybe to add something small.
Yes.
Because I can see you are wondering where cash gets involved, but you also alluded to something like land titles. It's in the law. This is in the law. And I will show you one of the sections in the MCA. Deposits instead of recognizance. And the deposit here is to deposit any specific article or property. It's in the law. And that is for the judicial officer to determine what article or what property. It is within the law. But based on the facts of the case, the issues that my brother has raised, And the fact that once this is what is done, this person will inevitably return to court and the justice. And I want to add something here that you see, and I want to know this. Chief Magistrate might have ordered you to pay a certain amount of money or even to deposit a certain article or property. Okay? But during the trial or at a later stage, it becomes necessary that you must furnish further security or further deposit. And an application is made to Mr. Kaizi that, you know what, there are these emerging circumstances surrounding this trial, and particularly the fact of this person's liberty on bail. And we are asking that he should be asked to furnish further deposits or further articles. And Mr. Kaizi, the Chief Magistrate, will entertain that application and is in the law right to say, please, you had been earlier ordered to pay cash 10 million. I'm ordering that you pay a further 10 million. I'm saying this because I know in the future these questions will come in and our people will be shocked. The man granted bail, but again he's also asking for another. It is within the law. Okay.
Now, does the law also specify you call them articles or what, or it leaves it to the Chief Magistrate?
We have definition sections which define what is an article.
Because some are arguing, where does the law call for a passport? Where does the law call for a land title? You know, money is obvious. What, you know, is it the judge who be asked cars?
You say the money is obvious. Okay. But even an article, as long as it has been clearly specified in the word, it will be obvious. I said article. The article is a land title. I said the article I need from you because of the circumstances and issues before me is the passport. I have specified it. So what is not obvious there? You know. So anyone who has issues with his trial are those who will always come up with issues. All right. Nevertheless, he has rightly said, should he make these decisions and one is dissatisfied with them, you appeal to the next level. Okay? You go to the High Court and say, the Chief Magistrate gave me these conditions, I think he erred in law and the fact, blah, 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 and the High Court will listen to you and either agree with him or agree with you, and the High Court will make the necessary. So we want our people to understand legal process. The due process which is available to our people. They should be going to Twitter, I don't know, X, I don't know, wherever. Those discussions there, they are healthy for us to understand where our people are going. And it's our responsibility to bring them back to the right path. That's why we are here.
Now, Chief Magistrate Uganda Road, Kaizi, now what happens in an incident that bail is not granted?
When bail is not granted, again, the Magistrates Court Act is very clear. The Chief Magistrate, all the Magistrate Grade 1 or Grade 2 who has denied bail must give reasons why. And should also inform you of your right to apply for bail in the High Court. That is very, very clear. Yes. And actually, we have the new bail guidelines. The new bail guidelines tell us that court can review the bail terms, as this worship has been discussing here. For example, if I've set a condition for bail and you cannot fulfill it for one reason or another, you come back to this court and you say, you had ordered me to present ABCD, I'm unable. Can you please review this? So what happens when bail is denied? One, bail terms under the bail guidelines, the constitutional bail guidelines issued by the Chief Justice. Alternatively, you can apply for bail in the High Court. Yes.
And the obvious thing is, if you are being denied bail, you go back on remand. Yes.
Then now you spend more in incarceration as you go for the process of applying to another court and higher.
That is the due process. We see the rule of law and respect for the rule of law. It should be a culture of Ugandans must be told. You see, because law is available to address.
Sometimes it's a bitter pill to.
I mean, just like people have a whole Bible with all answers to all our problems, but we refuse to read it. We refuse even to take out the simplest.
Now, this takes me also to another element of bail. Our viewer, we are discussing all you need to know about bail. I said you never know when you'll be before a magistrate and you're applying for bail. Because being in court does not mean you're guilty. Being a suspect, as the word is, doesn't mean you committed an offense. You can even later turn out to be a witness, yet you came in as a suspect, not so? Yes. So, you have to understand these things properly. Now I want to go to another element, Chief Magistrate. This is surety. Many times I've seen key people being denied bail, and one says that sureties did not satisfy the magistrate. And I'm like, but these are known people. I mean, how did they fail? I don't want to bring case by case because some are still ongoing. Professionally, I would be wrong. Most of them have people in the legal fraternity. But the incidents have felt naive for sure. How does a member of parliament fail to come through and you say they are not substantial sureties? Take us through.
Thank you. We used not to have a law to guide courts on determining the suitability of a surety. But we are lucky that the owner of the Chief Justice issued the constitutional bail guidelines, and paragraph 15 of these guidelines gives court what to consider to determine as whether a surety is substantial or not. One, what is the age? How old is the surety? Is he too old? Is he too young? Again, we look at the nature of the offense. Two, the relationship that this accused person has with the surety. How close are you that you can compel this person to come back to court? Where do you work? There's a case of Uganda versus Aliganyira. Justice Salivisa said that it's important for court to consider that this person who is standing as a surety has capacity to pay the non-cash bond if you absconded. Supposing I say you are going to secure a bond of 100 million, not cash. Really, you're a person who works somewhere and your earnings in a month is, let's say, 400,000. Will you be able to pay this bond, or you'll be incarcerated for 6 months in case this person absconds? So what do you do as a surety? A member of parliament, an army officer, a police officer, practically these are difficult to arrest. Suppose somebody absconds and you're going to pick a member of parliament to bring him to court. The entire constituency will surround the Uganda road. We want our MP. Yes, the MP executed a bond with this court, undertaking that will ensure that this person reports to court as and when court wants him. A general in the UPDF. Yes, you may. How can a general be not suitable? But will you arrest this general if this person absconded? So you want a person, one, who can ensure that you come back, but this person can also, if you abscond and court wants that person to come back to court and tell the court where this person is, you can easily be picked. So it's important. It's not about your stature in society.
Saying I have an uncle who is an MP.
Yes, that MP.
Who is a general, yes.
Can we pick the general? Can we pick the IGP? Can we pick? It comes, it wants to be a surety, but you're saying no, you are not suitable for those reasons. Yes.
And the problem has always been, and I want to chip in, we have known that hardcore criminals also know who to take to court as a surety. You see, they plan it. I will do this, go to court. I will ensure that my surety is X, Y, and Z. But, like he has just said, if it was planned to come and stand surety for you, and for you disappear, how will you order the arrest of the general? Who will even go to arrest him? To bring him to book. Okay? So the courts are cautious. So they really, there is a lot of work and brain work for judicial officer when determining the bail conditions and whether or not sureties are substantial. However, as a judiciary, we are moving the direction of scaling and empowering our judicial officers. Okay, because I don't want to underestimate your point. All right, that if a person is really presentable, okay, why shouldn't our judicial officers be comfortable? Okay, that this person is respectable, the fact that he has come. We want to tell the sureties, you have a responsibility. Because you don't just come and sign surety and you think it is a done deal. You have a responsibility to bring this person to court. They are needed. And if they are unable, you inform the court. You come and bring evidence of the inability. If he's sick, you want to look at medical forms. You don't just come and, you know, sensitive matter, witnesses have come from, some of them come from abroad. Before the advent of video conferencing, people would have flights here. Uganda Road, I have been there as a chief magistrate. I know the nature of cases there, okay? But you can imagine, you have some of the witnesses from Canada, from the US, from England, from wherever, they are here, they spent money, and then the accused person is not ugly. But if a surety is available, of that respect you are mentioning, an MOP, and he has come, I'm the surety X for Y and Z, the accused person had this problem, and here is evidence, so we request that the matter be adjourned to another. Even the witnesses and the other parties, even the entire court will agree and say, oh yes, but blanketly, the surety is not there, accused is not there, you are stuck there, you can see the ugly face, the court will take. Okay? And unfortunately, we become accusations. It becomes an issue of perceived corruption. That no, this particular case, these people, they got money and let this person away. So we want sureties we are satisfied with that will ensure the person will return until the conclusion of the case. We are sensitizing our judicial officers to understand those dynamics.
Now, so this brings me...
those dynamics, I want to say this. Those dynamics, we are looking at the amounts of money, the conditions. We are telling them, put a human face, okay, to our decisions, okay? A simple matter, these chaps fought in Chikubo, okay? It's an assault case before you in Uganda Road. Why do you ask for $1 million shillings? Okay, you know? So even other interventions, we wouldn't love to see these people go to prison. Why? It is already over-congested. What interventions? Reconciliation is there. Plea bargaining is there. Okay, we are trying to come in, putting the human face onto this, including the terms. We have sensitized them, and I'm very certain that with continued sensitization and education of our judicial officers, we shall now start seeing a positive trend in terms of conditions. Surely, we want to admit that sometimes we give too much, okay, too much money in some cases. But you know, this training is continuous, and we believe our judicial officers will come to appreciate the sensitization we are telling them, to be able to gauge a case and be sure that yes, if I asked for this amount of money, it's reasonable. If I'm having a bishop as a surety, I'm having a member of parliament, and we want members of parliament who are honorable. You know, they are, and I don't want to say it, okay? But anyone who has the respect for the law and respect for the courts comes clean. And we want to treat everybody as such, that all of us are in pursuit of justice, and so whatever we do, we are honest in what we are doing. And the judicial officer will exercise that discretion.
Yes, sir.
You must know that we have what we call professional sureties. These people, their job is to be sureties in courts. Yes. Actually, you know, my office at
qualify the word professional, because people
they are professional in such a way that that is their work. They don't know that I overhear them.
They are fake.
They even agree for you will be the uncle, will be the grandfather, you will be the mother-in-law. You get my point. So, Buganda, that street at Buganda Road has LCs of every area. Wakiso, Kampala, Najanankumbi. So these people actually, the so-called sureties are not even related in any way. Many of them to the, for example, when I'm in court normally, you say, what's your relationship with the accused person? Man, uncle. Which side? Mother's side. I give them cheats. You write the name of the mother, name of his mother. And actually 90% get it wrong. So to me, that means really that these people are actually hired to be sure.
At least I witnessed that at police, outpatient Apache police station, when it comes to bond. These are facts, viewer. I was surprised when, and was an officer who told me, no, if there are people here, you pay. And they are willing, they will photocopy their IDs. Like, goodness me, where have we gone? I know that even to the level of court it happens.
Yes, it's very common at Uganda Road. So bear with us. Sometimes we need to be sure that the people who are standing as sureties for their accused person are indeed sureties. They have a relationship with the accused person, so that we determine as whether to grant bail or not to grant bail.
Now, also very important, when we talk about sureties, what happens in the case this person absconds? Yes, James.
And this has caused a lot of issues. We have had instances where people are writing to complain that a court X are ordering them to pay money because an accused person they stood surety for disappeared. Some even are writing to say, is it in order for me to be asked to pay money when I'm not the accused person? I was only a surety. People need to understand that when you elect to become a surety to someone in court, you are entering into an undertaking with the court. You are going to, let me use this analogy, that other than
well, I have to apologize to my viewers and my guests as well, because today we are having the National Prayer Breakfast at State House, and His Excellency, he is the host of this prayer breakfast. Now, our judges and magistrates are very good in keeping time. Please, in a minute, just parting shots, we shall have more time for this. I'll begin with Chief Magistrate Uganda Road.
Thank you, UBC, for hosting me. I encourage our court users to always come to court, because every court has a leader. A Chief Magistrate has the court. In case of any issues, please come to us and ask us, and shall give you guidelines. We shall give you guidance on how to actually go about it.
Your Worship, James.
Yeah, thank you very much for listening to us. One important thing is, let us work together with the courts and the leadership at the courts and the judiciary to fight the vice of professional sureties, the fake ones, because they extort money from you. They even pretend that they are taking money to the judicial officers, whereas the courts are not part of that kind of game. We have a zero tolerance to extortion and corruption. Anyone who is asked to pay the money, please report, because you have not heard it from the judicial officer presiding. And if the judicial officer tells you pay so much and cash, go and pay to the bank and present a receipt, proof of which at the end of the trial, we want that proof that you paid the money and you claim your money back. Money is lying with us because people lost the receipts, people did not get receipts, conmen ate their money. I bring greetings once again from the judiciary. We love you so much. We shall be coming to educate our people, because empowering you with information solves all the problems you are facing there. Thank you very much, and may God bless you.
Well, thank you so much, Your Worship. James Eremie, who is the spokesperson of the judiciary, and Your Worship Ronald Kaizi, the Chief Magistrate, Buganda Road. Robert Chirabo Nyonyi Ntono. And I now hand over to the National Prayer Breakfast. Good morning and happy independence in advance.
Epoka, are you ready? Okay, the mic is here.
Yes.
You.